Hi, I'm Ian Linklip, the Consumer Insider. For 25 years, I've been helping consumers with their credit and debt issues, and I want to talk to you today about the Lemon Law and how a Lemon Law case can affect your credit and your credit report. So let's set the stage. You've gotten your down payment together, you went down to the dealership, you spent an entire day negotiating with the car dealer and the salespeople and the manager. You finally drove out with something that approximates the car of your dreams, and now it's been back to the dealer a half a dozen times, and it's been in the shop more time than you've had it out on the road. The car of your dreams has really turned into a living nightmare, and now you're stuck with the problem of filing a Lemon Law lawsuit, and you've had to find an attorney and get that case underway. The question that a lot of people have is, what happens to your credit report during the time when this case is pending in the court system? So the predominant question people have about this is, do I have to pay for the car while this Lemon lawsuit is going on? And what happens to my credit report while the case is going on? So let me start by just saying this. You should not have to have your credit report destroyed because you bought a defective car, a Lemon. So what we're going to talk about is how that credit is handled through the Lemon Law and what to do if there's a problem. So let's start with the basic idea that it's just not fair that you would have to pay for a vehicle that is a Lemon. You have every right to be upset that the vehicle is not running and that you would have to keep paying for this while the car is broken and not as it was promised to you. So if you want to stop paying for this vehicle, there are two big questions that most attorneys want to ask before we start talking about how it is that you might not pay for this vehicle. And the first one is, can you still drive the car at all? And by this, what we mean is there a defect in this vehicle that makes it unsafe or unwise for you to drive this vehicle? And a pretty easy example would be things like the transmission is out. We used to see a lot of car cases where when vehicles hit certain speeds on the road, they would just completely shut down. If there's problems with the steering, the suspension, or the fuel injection system, all of those things can be very dangerous, and you don't want to take that car on the road. So if you don't want to take the car on the road, or you can't take the car on the road, and it makes all the sense in the world that you have a problem where you cannot drive that vehicle. And then the other question is that we have to know whether or not you need this transportation during the pendency of your case. So while your case is still working its way through the system and you're trying to find out whether or not you're going to get a buyback and whether you're going to get a swap out of this vehicle, do you need this vehicle as transportation? Because there are a lot of people who may be able to find alternate transportation. They may have another car. They may have mass transit available. You may be able to catch rides with people. So we want to know these things because when we're looking at the Lemon Law case, we don't want to see the fact that you have bought a defective car cascade into another set of problems, like you losing a job, missing appointments, not being able to get to and from school, not being able to do shopping. If you need transportation, then we can start talking about making other accommodations. So we want to take that into consideration. Now, if you are still able to drive that car because there aren't mechanical defects and you still feel safe on it, then the Lemon Law has a pretty easy answer. The Lemon Law says that during the pendency of this case, there is no change in your obligation. So as long as this case is out there and hanging on through the system, you must continue making payments on that vehicle unless something else has happened to suspend that duty to make those payments. So whatever else happens, unless your attorney tells you otherwise, while your case is going on, you make those payments on time, and ultimately, after your case is done, you're going to get that money returned back to you, minus an offset for any use that you've had for that vehicle. So as long as you're making your payments on time, you are going to have your credit still be intact at the end of that lawsuit. And again, it's pretty crummy to have to drive a car that's not what was promised to you, but by the same token, as long as you are making those payments, you're going to get those payments returned back to you. Now, if you cannot drive the car, there's a different circumstance. You may have to find alternate transportation, and most judges will understand the idea that it is unfair to make you pay for a vehicle that you cannot drive. And in fact, there's another law out there called the Uniform Commercial Code that recognizes this. And it says that if you've been sold a defective good, including something like a car, you have the ability to suspend your payments while that case is pending. Now, these two bodies of law, the Lemon Law on the one hand and the UCC on the other hand, tend to work together. But the most important thing is that, number one, you have to follow the advice of your attorney, and number two, if you're going to try and stop making your payments, you want to do that under a court order. You want a court order put in place telling you and the finance company and the manufacturer, hey, it's okay that this person stops making payments. And there may be other conditions. You may have to set those payments aside in an escrow, or you may have to use them to put it forward to another form of transportation, or you may be just suspended. But whatever's in that order, that's what you're going to comply with. So if you can't drive the car and you need the transportation, you want to go back to your Lemon Law attorney and you want to let them know, look, I need to find alternate transportation and I want to suspend my payments. And they can begin the process of negotiating a payment order or a suspension of a payment order. Now, once the case is over, if you have complied with your requirements of making those payments or any order that's been put in place during your case, you should be fine, because the Lemon Law, if you're successful in your lawsuit, the Lemon Law says you're either going to get a buyback, which means that the finance company is going to have to return payments, that the manufacturer is going to have to return your payments, and you're going to pay those in turn to the finance company to discharge any loan that you've got out there, and you've been making payments this entire time, so your credit should be just fine. The other alternative under the Lemon Law is that you would get a swap of a new vehicle of the same make and model for the one that was defective. So you're just going to exchange those. And under those circumstances, the Lemon Law says that the finance company has to agree to allow you to substitute the one vehicle for the other, just as if you had originally bought that swapped vehicle. So the lien is just going to transfer from the one vehicle to the other, and it's going to be completely transparent on your payments. So what that means is it shouldn't have any effect on your payment history. Now, that being said, we know that the Lemon Law case should not affect your credit if you've complied with the law and you've complied with any orders that are in place. But mistakes happen, and they do happen pretty regularly in Lemon Law cases. So we see that every now and again, that finance company is not going to recognize the substituted collateral. They may not record the payment history correctly, or they may not be able to keep track of properly a stop payment order that might get put in place. So these kinds of mistakes happen, and when they do happen, that's when we're going to have a problem, and I'm going to tell you what you're going to do about that. So if the finance company has recorded you as not making payments when in fact you are complying with all the obligations under your agreement and the order, and it falls through down to your credit report and it shows either a default, a late payment, or a discharge of the loan, or I should say a charge off of the loan, under those circumstances you're going to have to jump into action. So what you do in those circumstances are that you would pack up any agreement that you had or any proof of your payments into a letter, a cover letter to the credit reporting agencies that are reporting this, and that letter would say something along the lines of, Dear Mr. Credit Bureau, I have made all my payments on the vehicle. This was a Lemon vehicle, and ultimately we either got a buyback or we got a swap of the collateral, and there was no default by me on that loan. Here's the proof of that. And you would send that over to the credit reporting agencies. You would send a carbon copy of that to the finance company that made the mistake. And ultimately, we would expect that that would get corrected on your credit report within a 30-day period after an investigation. Now, if that dispute is rejected, then you have a different problem, and that problem may result in you having to file another lawsuit under the Fair Credit Reporting Act. But normally, these kinds of disputes can be pretty quickly resolved, and we've got a sample letter for you on our website at consumerlawyers.com under the resources page, and you can see how that dispute letter would look if you need to write it. And it's the model letter that we provided is in MS Word format, so you can modify it as you need to. and you can put your own name and address in the top and address it appropriately to the credit reporting agencies that have made the mistake, if there is one. So if your credit dispute is rejected after you've had that lemon law claim processed, you can also take a look at our video on what to do if your credit dispute is rejected by a credit reporting agency. Now, that wraps it up for today. If you bought a lemon and that car was bought back, or there was a swap of collateral, you should keep making your payments while your lemon lawsuit is going on with your attorney, but ultimately it should not result in any damage to your credit report or your credit ratings. And as long as you comply with your court orders and your loan documents, you're going to be just fine. That's it for today. I'm Ian Linklip, the Consumer Insider. Thanks for spending some time with me. If this helped you, hit the like button, share it with a friend, leave a comment. I respond to those regularly, and we appreciate that. You can visit us at consumerlawyers.com. We can be visited on Twitter. Our Twitter handle is at MI Consumer Law, and you can visit our site on Facebook. We're the Michigan Consumer Law Center, Linklip and Associates. Thanks for visiting with us today.